Tell you what, why don't you get Judge Davis's nameplate from off there? It confuses me. No, just hand it to the clerk. Before we start, going to be more than one person, one lawyer arguing a side? Have you divided your time?
Yes, 7.5 minutes.
Okay, that'll be fine. Thank you. We're here for the appellant now.
May it please the court. I am Joe Bednar Sr., and along with my son, Joe Bednar Jr., we're of the Nashville Bar, and we represent the appellant, and we represented Chayce Collier in the trial court for both trials. We were here 6.5.
Counsel, you want to reserve any time for rebuttal?
3 minutes, Your Honor.
3 minutes. Thank you.
We were here 6.5 years ago. Two of you were on this panel 6.5 years ago. We were here asking for new trial based on a failure of the defendants to supplement discovery when the nurses had changed their testimony and we weren't notified of it. The court agreed and granted us a new trial. The trial was conducted the second time in July of 2019. And we're back again, asking this court once again to give us another chance, to give us another trial. We have alleged several errors, the most notable of which is juror misconduct and the actions of the trial court in regard to that juror misconduct. Shortly after the trial, we talked to some jurors, and we found out that a Mr. Jacobson, one of the jurors, had done some independent research over the weekend. We got affidavits from two of the jurors, submitted them to the trial judge, and even without a hearing, just on receiving the motions, Judge Ayler granted us a new trial and set the trial rather quickly. The defense filed a motion to alter and amend, and then in February 2020, the judge reversed himself and denied our motion for new trial. He stated at the time he was reversing himself that in reviewing the affidavits that we submitted, they did not contain any testimony that this extraneous information affected the verdict in any way. And he went on to say that in his reading of 606B, that 606B allows questioning of the jurors as to how the extraneous information affected them. And then he went on to say that the Colorado court ruled that the standard is that prejudicial information must be proven by clear and convincing evidence, and that the plaintiffs had not met their burden in proving by clear and convincing evidence that the extraneous information affected the verdict. He was obviously wrong on the law. I think that was pretty clear. He was relying on Whiteside v. Hedge, which is an opinion of this court. But in any event, we filed a motion asking the court to reconsider. There was a discussion with the trial judge about getting further affidavits from the jurors, and he would consider them. We found out clearly we could not get affidavits from the jurors on that topic. He took our motion under advisement for 2 years before rendering a decision denying our motion for new trial. In order to determine if this medical research was prejudicial, I think it's important and it would be helpful to the court to look at some important facts that underlie this issue. Kendall Collier tested positive for Group B strep. She received a shot of penicillin or ampicillin and immediately had an adverse reaction to it, and she had anaphylaxis. All of the physicians agree the standard of care or the treatment for anaphylaxis is epinephrine. I'm getting ahead of myself. Dr. Roussis was called to the bedside and did not administer epinephrine. In a progress note written immediately after the event, he stated that he gave Benadryl and Brethine. Then I quote, "No EpiPen on floor at that time," end of quote. Based on that representation, there was no epinephrine on the floor. We sued the hospital and brought them in. When we took his deposition, Dr. Roussis changed his testimony, or changed his opinion as explanation as to why he didn't give epinephrine. He stated the epinephrine was available, and I purposely did not give it, is what he said. I determined that the risk to the fetus outweighed the benefits from the epinephrine. Also, her blood pressure didn't drop, so we weren't concerned about her. At trial, all four of our experts, 2 maternal fetal specialists, an OB, and an allergy specialist, all testified the standard of care is you give epinephrine no matter what. Whether you're pregnant, not pregnant, blood pressure high, that there are no contraindications to giving epinephrine. And he should have given epinephrine. The defense, on the other hand, they had several experts that testified the same as Dr. Roussis, saying, oh, you can weigh the risks and benefits, and as long as the blood pressure don't drop, it's okay. So those were the fighting issues right there. Mr. Jacobson, one of the jurors, apparently wasn't satisfied or couldn't make up his mind, and the jury was sent home over the weekend. He did some independent research and found some warnings about epinephrine, and he came back to the jury and shared this information. And that information was, and I quote, "Epinephrine should only be used when the potential benefit justified the potential risk to the fetus." This was exactly what the defense had been arguing. So it completely supported Dr. Roussis and his experts and contradicted the 4 experts that we had.
Let me ask you a question.
Yes.
The trial judge's reason for ruling against you is that you did not present to him information as to how this independent research affected the jury's decision. Is that correct?
That is correct, Your Honor.
Now, how do you do that, though?
I don't think you can.
Can you present information to affect that as to why the jury came into, why they made a decision? Can you actually deal into that?
No. See, 606B prevents us from questioning the juror as to their state of mind or how it affected. So in reality, there's no way to prove how it affected the jury. And that's the reason that the case law, I think, is clear, and it falls back to where the trial judge or the court can determine if there's any reasonable possibility. So, and that was the problem. See, Judge Ayler was of the opinion that we had to submit proof that it affected the verdict. And there's no way to do that. I mean, how can you, if you're not allowed to question the jury on that topic, how could you ever prove? And especially by clear and convincing evidence. So he applied the wrong standard.
Yeah, but what do you say is the standard? I mean, I'm not sure that it's all that clear, frankly, from our opinions, one of which I wrote. Exactly how the process is supposed to go through if the jury it's no question here, the trial judge found the jury was exposed to extraneous information.
Yes.
What happens after that? Who has the burden to do what, and when does it go? Do you all say it is?
Okay.
And then,
As I understand it, Judge, and I'm not an appellate lawyer, and I had difficulty, I read all those cases, and I think it comes down to 606B, the Calderero decision, Walsh versus State, and State versus Adams. And basically, we have to prove it was extrinsic and that it was prejudicial. Now, once we prove those two elements, and in this case, I think it's clearly extrinsic, clearly prejudicial, because it went to the central issue of the case. Which side are you going to believe? Mr. Jacobson went out, got that information, and used it as the tiebreaker. He hears from the plaintiffs, experts, he hears from the defense experts, he don't know what to do. He does his own independent medical research as a tiebreaker. So once that is done, I think the cases, State v. Adams is very clear. Then the trial judge, or in this case the Court of Appeals, I think you applied the standard, is there any reasonable possibility that it affected the verdict? And I submit that those Supreme Court cases, and I think one of the problems out there now is there's a lot of cases, and we've got the Whiteside v. Hedge decision out of this court, get Mayo out of this court, but they are in direct conflict with the Supreme Court cases. I think the Supreme Court cases clearly show that as long as we prove it was extrinsic and that it was prejudicial, and in this case, may I please go, I don't see how you can say it could not be prejudicial when it goes to the central issue and it's medical literature not subject to any cross-examination. It goes to the jury or a juror in writing. And I think the standard then is there any reasonable possibility? Judge Ayler certainly thought it was the first time. The second time he found, I think, as I read his opinion, that it was extrinsic, it was prejudicial, but then he thought we had to prove the third element by clear and convincing evidence. He applied the wrong law. That is not the law. There's no way you could ever do that, I respectfully submit. Judge, I'm running out of time. I didn't write this brief, but as I prepared for this oral argument, I realized that I probably can't add anything to these other elements. So in terms of the other issues, we're just going to rely on our trial brief. And I'll save the rest of my time just for rebuttal on any issues that they may raise. Unless your honors have some questions on any of those other issues, I'd be glad to try to answer them both.
I hear no questions. You have your time for rebuttal.
Thank you,
We'll hear from the appellees.
May it please the court. My name is Grant Llewellyn of the Knox County Bar. I had the privilege of representing Dr. Roussis in both trials and at the appellate phase. I will be addressing primarily the juror misconduct issue. Also, if there are any questions on the issue of the grant of partial summary judgment for the amoxicillin June 1st order.
Let me ask you quickly on that one, that issue. Was there was there a claim that there was malpractice as to the administration of that initial one?
Yes, there was.
That it never should have been administered?
There was a newly asserted claim of negligence.
As to that
June 1st order.
Okay. All right, go ahead.
That affidavit support shows that Dr. Roussis did not order, that there was no mention of in the original complaint. Other issues will be reserved for Ms. Hurt to address, and to the extent there are additional questions that I'm unable to answer about juror misconduct, Ms. Hurt can also address that. So with respect to the juror misconduct, after the second trial, there were two affidavits that were provided in support of plaintiff's motion for a new trial, it's important to consider the actual substance of those two affidavits, which say nothing about medical research, nothing about medical literature, nothing about any written material being brought into the presence of the jury. We just heard all of that from appellant. None of that is evidence that was before the trial court or before this court.
Was the results of the investigation brought into the presence of the jury?
We don't know if there was an investigation or if this was
Inquiry.
We don't know. Based on the affidavit, this could have been Mr. Jacobson's own EpiPen that he had at home, which could be part of his own personal experience and life experiences.
That makes a difference how?
It makes a difference from the respect of what the basis for that juror's knowledge base that he brings with him to jury deliberations.
Did he share that with the other jurors?
Based on the affidavits, he shared that information, yes. So I don't think
The affidavit stated he had gone home over the weekend and looked at the warnings on EpiPens.
Yes.
So he looked at the warnings on EpiPens, whether he pulled them up on the internet, whether he looked at an EpiPen he had. What he told the other jurors were, I went home and I looked at the warnings on the EpiPens.
Yes. And I don't think that's material to this court's determination.
Really?
I think clearly we can see this is extraneous information.
Yes.
When you look at the testimony that this jury heard for 2 weeks, sat through for 2 weeks, from 8 different medical doctors, 4 of whom testified for appellant, all of them agreed to the two statements in Juror Jacobson's communication to the jury, that caution should be used with epinephrine or EpiPens when you're dealing with a pregnant patient, and you only give it if the risks are outweighed by the benefits.
Let me ask you about that second statement. Doctors only give this when the epinephrine, when the risks are outweighed by the benefits. Isn't that so for every medication a doctor prescribes?
Should be, yes.
Yeah, they always look at it and say, what are the risks, what are the benefits? Okay.
Yeah.
This was a warning, correct me if I'm wrong here, what the juror's affidavit said, this was looked at the warnings on EpiPens. So not what he didn't tell the jury that, what he said, this is what's actually on the EpiPen. This is a warning on the EpiPen, right?
Based on the affidavit, yes.
Yes, okay. I'm sorry, go ahead.
So we can see that could be extraneous information. When you get to the second prong, which this determination is not lumped into one consideration. Is the information extraneous? Is it prejudicial? And did it have an impact on the jury? So we argue that Judge Ehler, if you read his 9-page order when he denied plaintiff's motion to alter or amend, he spells out his thought process his analysis very clearly of, while this is extraneous information because it came from an outside source, there's no way this could be prejudicial because the central issue is not whether there was a warning to give epinephrine. The central issue is...
How can we judge that, though? How can we judge how that's going to affect each juror when this information has been presented to them?
Well, I think that's what we have to, based on how 606B stands, you have to take the information that was the extraneous information based upon the context of what the jury actually was supposed to base their determination on, and see, based on what the affidavit, the juror testimony is, based on what the evidence at trial was, and determine, was this prejudicial and did it have an impact on the jury? And we submit, based on what the jury heard for 2 weeks from 8 experts, all of them agreed with the contents of what Juror Jacobson provided. There's no way this could be prejudicial.
You don't think it supported what the defendant's experts said?
It did, but it also did not...
So supposedly, I'm sorry, go ahead.
It did not contradict what plaintiff's expert said. The central issue in the case is based upon this recognized warning, this recognized risk that every expert agreed to, did the standard of care require Dr. Roussis to order epinephrine to be administered? They said no. They said epinephrine should be ordered. We said it shouldn't be ordered based upon the standard of care. Breathine was an appropriate alternative. That's what the jury
What's the
determined.
what's the standard here? Excuse me, I mean, is it clear and convincing? Is it preponderance? I mean, who has what burden, when, and where? And I've written one of the opinions that y'all talk about.
I like the burden
I thought
put
you
in
would,
there.
where I use clear and convincing, yeah.
I don't think it ultimately matters. I think under either standard, they still cannot carry their burden of proving that this was prejudicial. Under either
How
standard.
can they carry that burden? I mean, 606B prohibits anything, as I recall, from, asking anything about the deliberations, basically. So how could either they or you, plaintiff or defendant, ever show that something actually did affect the deliberations?
I think if the affidavit support shows information that was not addressed at trial.
Why does it have to be information? And I know there's a case that talks about that, but this goes back to the question I asked you a minute ago. Did this information supported primarily your client's position?
I don't think it supported either position. Like I said, the main issue is based upon this recognized risk that everyone agreed to, did the standard of care require epinephrine or not? So I don't think it supported the defense versus the plaintiff. Everyone agreed to it. It wasn't disputed. The dispute was based upon that risk. What's the next course of action? Do you give epinephrine or do you not? And that's how this cannot be prejudicial. This information from Juror Jacobson.
Okay, thank you. We asked you a lot, and I'm sure you didn't get much said.
Thank you.
I'm a little bit shorter. Is it permissible to move this way, or is that a forbidden concept?
You're fine, just move the mic to you.
Okay,
Definitely.
thank you.
That'll be fine.
Good morning, Your Honors. Rachel Hurt here on behalf of Fort Sanders Regional Medical Center. I was actually here prepared to talk about the other 7 issues that don't quite seem to be the focus here today. And so I'm going to follow up on the issue that's been the topic so far this morning. And I'm going to focus entirely on prejudicial, although I want to answer the questions that I think have been raised with regard to clear and convincing versus preponderance of the evidence. If you look at the totality, if you just look and measure which one the court has cited more, it has been clear and convincing. But under either standard, I agree with Mr. Llewellyn. The plaintiff cannot carry the burden, and I want to focus on prejudice. And this is how I look at whether the information, or I think it's analogous to look at whether that information was prejudicial. Mr. Jacobson, assuming he walked in and said, I've read the label, and it says caution and potential benefit must justify. Any other juror in the court, in the jury deliberations could have said, you know what? I've looked at my notes, and every expert said that as well. I don't need to look at a label that you looked at over the weekend, because every expert used those exact same words. Caution. You had to use it with caution. Plaintiffs' 4 experts, they're allergists, Wegner, Vlastos, Thorpe, and Bryan, all said, yes, this is a medication that you must use with caution. They all said that.
Did the experts, any expert testify that you always give it in the situation like this? Any expert testify that, in this situation, yes, you give it?
Yes, the plaintiff
In
expert.
other words, that the benefits will always outweigh the risk.
They didn't say the benefits, the testimony was that in this situation, the benefits outweighed the risk. The label on the EpiPen doesn't say anything different. All it says is you must justify that the potential benefits outweigh the risk. That's what their expert said. In fact, their expert said exactly those words. Dr. Wegner, their allergist of 35 years, impressive resume, he was expressly asked, do you agree that the justification has to be that the potential risk doesn't outweigh the other factors, the potential benefits? And he said yes. And so if you're looking at what the label said, plaintiffs' experts said those things. I respectfully
So how much weight do we look at as far as laying on what the what the juror told his other jurors, how much weight should we put on that versus the information that was received during the course of the trial?
Well, I think that the inquiry was what he told the jurors prejudicial? And if they had already heard it from 8 experts in trial, how was it prejudicial? And where I was going to that is I respectfully disagree with Mr. Bednarz that the dispositive issue was whether the risk outweighed the benefits or whether there was a label or what the label said or whether there was caution should be used. To your point, Judge Sweeney, in fact, Dr. Bryan, their expert, exactly said what you said. With every medication, caution has to be considered. With every medication, you have to look at the potential benefits and see if they outweigh the potential risk. That's how commonplace it was. So I 100% agree. Of course the label says that. Most drugs say that. But the point here is how can it be prejudicial if both parties said it, 8 experts equally, 4 and 4, said these exact same things, but the dispositive issue is then the balance of did the risk outweigh the benefits or did the benefits outweigh the risk? And the label, the affidavits made no reference to any considerations of how to do that. That was entirely upon the expert proof as to whether there were more risk or more benefit. And in this instance, the jury determined with the defendants that there were more risk and therefore there was a benefit to giving another medication.
Let me ask you,
Yes,
I'm
sir.
sorry, refinish.
Go ahead. I'm so sorry.
The trial court said the court's opinion with regard to this evidence would be that the evidence had to have an influence on the jury. However, the court's opinion with regard to not plaintiffs have met the standard of clear and convincing evidence is the plaintiffs have not met that burden. So didn't the trial court find it had to have an influence on the jury, but it's not clear and convincing?
I think the words of the opinion could have been better. I think there's a difference between influence and prejudice. I'm allowed as a juror to bring my own influence into the jury deliberations, but I can't bring prejudicial influence into the deliberations.
Well, this said the evidence, extraneous evidence, had to have had an influence on the jury.
Again, but was it prejudicial? And I think that's the distinction. I think that I would disagree with the court. To sit there for 13 to 12 days, jury days, and to hear every expert say caution, potential risk, must justify, to then somehow conclude that a label saying the exact same thing was prejudicial. The analogy
Is the fact that the label is from a entity, corporation obviously, that has no dog in this fight, you think maybe a juror might give that more credence
I think the jury...
than a hired expert for either side?
I think that if my analogy, I'll say, is this, Your Honor. If I'm sitting on a jury in a car wreck case and the issue is whether the light was red or green, I'm a jury, I drive home, I want to see what the intersection looks like. I drive through the intersection, I come back to jury deliberations the next day, and I go to the jurors and I say, you know, there are lights controlled at that intersection. There are lights there. It doesn't change the analysis of the dispositive issue as who had the red light. It's undisputed that there were lights at the intersection. The argument is, right, red or green. That's no different here. If it wasn't to the dispositive issue and all parties agreed on this issue, then how can it be prejudicial? How can it change the outcome of the jury?
Another question.
Yes, sir.
I may have misunderstood, but treatment for, this was, I think, Dr. Weber, testified that the treatment, and I cannot begin to pronounce it, anaphylaxis?
Anaphylactic.
Thank you, anaphylactic, okay.
Yes, Your Honor.
Anaphylaxis is epinephrine. Question, always, answer, always.
Always.
Always. So that the benefits will always, and by his testimony, always outweigh the risk.
But
is that what he said?
It is, but also what he said is, in a pregnant lady, in labor or not, epinephrine should only be used if there is justification for such the potential risk to the fetus is outweighed by other factors, correct? Yes, that is correct. I mean, it's the totality of his testimony. He absolutely said exactly what the label said. He was confronted with that exact label in the first trial, and he conceded, yes, that's right, that's what the label says. And so we didn't even have to talk about the label in the second trial because it was conceded.
Well, counsel, he went on and said on cross, I think it was on cross, No, this is on redirect. And how often do the benefits outweigh the risk when you're talking about the administration of epinephrine when faced with, still can't say it.
Anaphylaxis.
Thank you.
Yes, sir.
That's one of the words that just
I'm learning all
bothers me.
kinds of medical words in
Yeah.
this job. Yes, sir.
And faced with anaphylactic, answer, always.
And that was his opinion in the
Always.
presence of what the label says.
But my question to you is,
Yes,
this gets back to where I asked you a minute ago about, you have this information given to the jury that comes from the manufacturer, somebody that has no dog in this fight at all, is not a hired expert for either the plaintiffs or the defendant. And the manufacturer certainly seems to say, well, there are going to be times you got to outweigh the risk and the benefits, which certainly, does that not imply that there are going to be times when the risk outweigh the benefits?
The label says the risk have to outweigh the benefit, or the benefits have to outweigh the risk. And I'm sorry, what was the second part of your question?
Does that not imply that there will be times when the risk outweigh the benefits?
Again,
Well, even more than that, the information that they received at trial, regardless of what was said, the testimony that was presented, that testimony was received at a trial where there was an opportunity to cross-examine the witness and test that testimony as it goes to the jury. What about this information that's on the label?
I'll answer both questions. The label was absolutely crossed and directed because both parties agreed what the label said. The EpiPen is used in all
It
circumstances.
wasn't crossed and directed in the trial.
Yes, sir, it was.
The
Absolutely.
label, the label that he looked at,
Yes, sir.
was that label presented at the trial?
No, but the label in its context that was discussed expressly. Do you agree that the literature, the label says these things, and all parties said yes? But the distinction is an EpiPen is used for all types of patients. What Dr. Wedner was saying, what Dr. Bryan was saying, is that in babies, in mothers, in laboring mothers, in this circumstance, you use it. It wasn't talking about EpiPens used, at my child's soccer game. And so the label was true always. What Wegner was distinguishing is when there are children present, or when in this situation with laboring mothers. And so again, the label is not contradictory or prejudicial to what was heard at trial.
Who had the burden on that? And what was it? Did the plaintiffs have the burden to prove it was by clear and convincing evidence that it was prejudicial? Did they have to show that here's some extraneous evidence that was presented to the jury that the trial judge found was prejudicial? And then the rebuttable presumption arises.
I think the burden is, like in most cases, the plaintiff carries the burden to prove at first that it goes to a prejudicial dispositive issue, because that's how you determine that it affected the outcome. It's got to go to a dispositive issue.
So you're saying the trial court, and I don't mean to put words in your mouth, but that trial court was incorrect and it made a determination that this had to have an impact on the jury.
I do. I will stand, yes, I absolutely assert that.
Okay.
And then I think, to finish the question, the burden then shifts to us. If plaintiff ever carried their burden, it shifted to us to defeat the rebuttable presumption.
And what did you present to defeat the rebuttable presumption?
The testimony of every single expert that said the exact same
Okay.
thing as that
All
label.
right, okay. Thank you.
I went way too long. I do apologize.
Yeah,
Thank you.
Thank you. We'll hear from the appellant in rebuttal. You went way too long because we kept asking you questions. Hear from the appellant.
Your Honor, we addressed this issue in our reply brief as to what our experts testified to. On cross-exam, they did answer questions in line with what was just explained, but they went on to explain it, and every single expert we had, Judge, said that in a severe anaphylactic reaction, the benefits always outweigh the risks. You give the epinephrine no matter what. And they made analogies, just like the people that carry EpiPens for bee stings and peanut allergies. When they have that, you give anaphylaxis, that's it. That's the standard of care. There's no difference whether it's pregnant, no difference whether the blood pressure is high or low. And every one of the experts, and I would really ask you on that topic to read our reply brief, because we pull out the quotes, and every one of our experts stated the benefits always outweigh the risk, and you must give the epinephrine.
Okay, but as I understand their argument, they're saying, look, what this information the juror brought and shared with the other jurors is, all the experts agreed that whatever drug is prescribed, a doctor should always, the standard care requires the doctor always to decide that the potential benefits outweigh the potential risk. And they're saying that that's all that was, that information, as I understand what they're saying, that information presented to the jury was exactly what every expert testified to.
Well, that's not exactly accurate, Your Honor.
Well, that was my statement, so if it was inaccurate, it was me and not them.
I think it was clear that you had experts on both sides. One, clearly he had given no questions, no contraindications of any kind. And you had the other experts who were saying, well, Roussis could do that as long as the blood pressure was okay. It's okay to watch it. And that's why I say Mr. Jacob was looking for more information, and he used it as a tiebreaker. That is what pushed him, I respectfully submit, to find in favor of the defendant, and he thought it important enough to share it with the other jurors. Judge Ayler was correct the first time when he granted a new trial. He was correct the second time when he said it had to have an effect on the jury. The only place he went wrong is he thought that we had to prove by clear and convincing evidence, by affidavit, that it affected the jurors, and told us to go out and get juror affidavits. But we couldn't do that. We're prevented from doing that. So even the trial judge agreed. Clearly, it was extrinsic. It had to have an effect on the jury. And then the only question with him was he applied the wrong legal standard. We respectfully submit and ask the court to grant us a new trial.
Thank you. Of course, thanks to counsel for both sides. We appreciate your arguments and your briefs this morning.